Imagine you're a young graphic designer in Addis Ababa. A restaurant owner approaches you, asks you to design a logo for 5,000 birr. You shake hands and you start working. No paperwork, no signatures, no witnesses. Is this a real contract? Can you actually sue if the owner refuses to pay? The answer lies in Article 719 of the Ethiopian Civil Code. Let's look at the exact words of the law. Article 1719, titled Form of Contracts, states the following. Subarticle 1. Unless otherwise provided, no special form shall be required and a contract shall be valid where the parties agree. Subarticle 2. Where a special form is expressly prescribed by law, such form shall be observed. Subarticle 3. The parties may stipulate that the contract shall be made in a special form. 3 short subarticles, but together they create the entire framework that governs how contracts must be made in Ethiopia. Memorize this structure because everything else flows from it. Now let's break down each element carefully. Subarticle 1 establishes what lawyers call consensualism. Consensualism is the foundational principle of Ethiopian contract law, and it means something very simple but very powerful. A contract is formed and becomes legally binding the moment the parties genuinely agree. Nothing more, nothing less. You do not need to write anything down. You do not need to sign a document. You do not need to appear before a notary. You do not need to perform any special ceremony. In the overwhelming majority of everyday contracts in Ethiopia, a simple verbal agreement, a handshake, a nod, or even a clear course of conduct showing mutual assent is enough to create a binding legal relationship. A contract to sell goods, to provide services, to lend money, or to perform work can all be concluded informally. Why does the law adopt this generous approach? The reasoning is rooted in both practicality and respect for individual autonomy. Think about it. If the law required formalities for every single contract, daily life would become impossible. Every time you bought bread, hired a taxi, or asked a neighbor to fix something, you would need paperwork. This would also exclude large portions of the population, particularly those with limited literacy or limited resources, from accessing the legal system. By making consent alone sufficient, the law recognizes that human beings enter into countless binding arrangements every day without paperwork. Notice the phrase, where the parties agree, in Subarticle 1. This reminds us that the essential ingredient of a contract is genuine mutual consent. Form does not create a contract, agreement does. But Subarticle 1 begins with the crucial words, unless otherwise provided. This signals that there are exceptions. The first exception comes in Subarticle 2, which says, where a special form is expressly prescribed by law, such form shall be observed. This means the Ethiopian legislature has, in specific situations, decided that the parties' agreement alone is not enough. The law steps in and demands that the contract be concluded in a particular way, such as in writing, with signatures, with witnesses, or with registration before a public authority. Pay close attention to the word expressly. This word is significant. A formal requirement must be clearly stated in the law. It cannot be implied or inferred. If no provision of law explicitly requires a particular form, then Subarticle 1 applies and no form is needed. When a form is legally required and the parties fail to comply, the consequences can be serious. The contract may be rendered invalid or unenforceable, and the parties cannot simply agree among themselves to waive a form that the law has imposed. Why does the law sometimes require special forms? Formal requirements typically serve 4 protective functions. First, an evidentiary function. A written or notarized document creates clear proof of what the parties agreed. Second, a cautionary function. Requiring formalities slows down important transactions and encourages parties to think carefully. Third, a protective function. Some formalities protect weaker parties or third parties. Fourth, a public policy function. Certain transactions, like transfers of land, have implications for public records. Now we come to Subarticle 3, which introduces a third category. The parties may themselves stipulate that their contract shall be made in a special form. This provision recognizes the autonomy of contracting parties to impose formality requirements on themselves, even when the law does not demand any particular form. Sometimes parties dealing with each other on an ongoing basis will agree that any future agreement or any modification must be made in writing, must be signed by both parties, or must be witnessed. Why would parties voluntarily impose formalities on themselves? Several reasons. First, certainty and clarity. Written contracts reduce misunderstandings. Second, internal authorization. Larger organizations may need written contracts to ensure agreements are properly authorized. Third, seriousness. Requiring a signed document signals that the parties treat the matter seriously. If the parties have agreed their contract must be in writing, then a later oral agreement, even if both parties genuinely consent, may not be binding. Let me show you how this works through 3 concrete examples. First, consider Almaz, the graphic designer in Addis Ababa we mentioned at the start. She verbally agrees with Tesfaye, a small restaurant owner, to design a logo for 5,000 birr. Nothing is written down. They shake hands and Almaz begins work. Under Article 1719(1), this contract is perfectly valid. No special form is required for a service contract of this type. If Tesfaye later refuses to pay upon delivery of the logo, Almaz has a legal claim based on their oral agreement. Of course, proving the exact terms of an oral contract in court can be more challenging than proving a written one, which is why many parties choose to write things down even when not legally required. Second, consider Bekele, who wishes to sell a plot of land to Hiwat. Both parties agree on the price and shake hands, but transactions involving immovable property fall under specific provisions that prescribe formal requirements, including written form and registration. Under Article 1792, where a special form is expressly prescribed by law, such form must be observed. The oral agreement alone is not sufficient. If they fail to comply, the transfer may not be enforceable or may not be valid as against third parties. Third, consider a large Ethiopian import-export company that enters into a long-term supply agreement with a manufacturer. Their written contract contains this clause: no amendment to this agreement shall be valid unless made in writing and signed by authorized representatives of both parties. 6 months later, a sales manager from the importer calls the manufacturer and verbally agrees to change the delivery schedule. When a dispute arises, the manufacturer argues the verbal change is binding, but the court will look at the parties' own contract. Because they stipulated that amendments must be in writing and signed, the verbal conversation, even if it genuinely happened, does not constitute a valid amendment. The party stipulated written form requirement has the same binding force as a legal requirement. Now for your exam tips. First, remember that consensualism is the default rule under Article 1719(1). Contracts in Ethiopia are valid simply upon the parties' agreement, with no special form required, unless the law or the parties themselves specify otherwise. Second, know that legal form requirements must be express under Article 1792. Such requirements cannot be implied or assumed. Third, understand that parties can create their own formality requirements under Article 1793, and once stipulated, this party-agreed requirement is binding. Be ready to explain the 3-part structure of Article 1719: freedom of form, legally mandated exceptions, and party-stipulated requirements. A common pitfall is assuming that all important contracts must be written. They do not need to be, unless the law or the parties say so. Thank you so much for watching. Whether you're an LLB student preparing for your contracts exam, a legal professional refreshing your knowledge, or simply a curious member of the public interested in understanding Ethiopian law, we appreciate your time. Please subscribe and stay with us for more clear, practical explanations of Ethiopian law.